Thank you for joining us. The webinar will begin in just about 1 minute. Hello, this is Mark Diamond from Contoral, and welcome to part 1 of our 9-part webinar series on complying with the California Consumer Privacy Act, as well as other emerging state privacy laws. This is a 30-minute webinar, and it's the first of a series of 9 that we're actually going to be doing. And we decided to break this down into small chunks, and we're going to go through a lot of information through all 9 of them. This one, we're going to give sort of a brief overview of CCPA and what we're seeing in terms of other state privacy laws and some of the updates coming up. The next one we're going to do in a couple of weeks is how do you actually plan a project? And then we're going to jump in talking about personal data inventories, updating policies, managing files and emails, developing the key processes, legacy data deletion, organization development, and then sort of capping it off with lessons learned. The focus of this webinar series, we're going to endeavor and to make it as practical as possible. Many of the people attending really face some issues and questions as not only what it is, but how do we do that? And we want to make this clear to everybody. Recording will be available. Give us a day to be able to post a recording of the webinar. So if we go quick, you can always refer to the webinar recording, and likewise ask some questions, and we're going to see we may go a little bit beyond 30 minutes at the tail end with questions for those that want to stick around. And likewise, this will be one of a 9-part series out there. And so let's talk a little bit today about what is CCPA and what are the updates and what are we seeing in terms of some of the other states doing out there and what's happening about. And I'm going to basically start out by making a statement that we believe that the California Consumer Privacy Act will be the most impactful privacy legislation that most U.S. companies are going to face. We believe that they're going to be more impactful above and beyond GDPR. And likewise, as we'll talk about in a little bit, we believe that many other states, if not the federal government, are going to model similar privacy legislation out of what's happening in California. But let's start. What happened with CCPA and how did we get here? To net it out, there was a lot of concern in the first part of 2018 about reports about privacy information being used to sway elections. And specifically, there was the Cambridge Analytica scandal. And that created a lot of concern among a number of Californians. And there was a ballot measure that was created by Alistair McTaggart, who actually is a developer, believe it or not, a real estate developer, but he took a strong interest in privacy and was able to sponsor a fairly strict initiative out there. But he actually negotiated with the California legislature and said, in lieu of me putting this on the ballot, maybe we can pass some legislation now. And so Alistair took sort of a bird in the hand is worth initiative, two initiatives in the bush, if you will, to turn a phrase. And so basically, after only a couple days of debate, California opted for a fairly strict, but less strict than would have been had it gone to initiative, privacy initiative. Enforcement begins on January 1st, 2020. We're going to talk about that. It's in effect right now, but enforcement begins there. And the legislation guarantees California consumers 5 key requirements. This is very important, is that there are some penalties associated with this brought by the California Attorney General. Probably the biggest issue is that for breaches of data, it can be up to $750, or the amount of or damages, which is greater per consumer per incident. So, just doing some simple math, we think that this is going to be extremely impactful. And what's interesting about this, if you look at other privacy legislation like GDPR, we were talking about GDPR and had a general idea of where it was going 3 or 4 years ahead of time. In this case, we really have at best maybe a couple years, a year and a half until the January 1st, but it's going to be after that we think the enforcement's going to happen out there. But it's going to be very impactful. And the 5 key CCPA requirements, California residents, people who live in California, domiciled in California, and California employees. By the way, there's some confusion out there, and I've heard this. You don't have to be a California company. All you have to do is have information or personal information about California residents. You can be located anywhere in the world, and you have to comply with this legislation. I've heard some people say, well, we're not in California. It's some business to say, and so we don't need to worry about that. We do not believe that that's the case. It's about California residents. California residents will have to know what personal information is collected about them. What do you have? To whom have you sold or disclosed it? Show me what you've collected about me. What actual information if you have? And that raises a lot of questions about what it means to be able to produce information and what level of detail, and can you summarize it, or do you actually have to get down? And if it's in a difficult format, such as in a database, how do I have to present that information? California residents will have the right to have their personal information deleted. They can make a request saying, delete all this information. This is somewhat akin to the right to erasure that we saw in the European data privacy requirement, but it is a right that California consumers have. And likewise, California consumers have the right not to be discriminated against. And so you can't differentiate between consumers that want to have their information deleted versus those that don't, although there are still a lot of questions remaining about how does that impact things like loyalty programs and other information. Probably the most impactful of all of these requirements are number 3 and 4, which is what information has been collected. Can you show me what you've collected about me? And please delete my information if I ask you to. And so we think that's going to be a really big impact of this. Now, the law is changing, and there were some amendments that were put forth on August 30th. It will go into effect immediately. We talked about that, become operative on the 20th, but they're also going to extend the deadline in which the California Attorney General must publish implementing regulations no later than July 2nd, and you have a 6-month grace period between when the regulations or the implementation guidelines are published and when the implementation will go into effect. The operation will become effective, this law. At this point, our best guess at the California Attorney General, based on there's been a series of public hearings in the last month that are actually continuing into this month. And we think that the California Attorney General, what they told us is they're going to be implementing this in coming up with a lot of those rules in the late summer timeframe. So the effective date for when most organizations really need to be at the ready button is going to probably be past January 1st, 2020, although be careful. There's a lot of work there, and we're worried that many organizations are thinking, oh, I've got time. And as we talked about it, we think that this is actually a fairly short implementation period. There's a lot of work that needs to be done with this. By the way, consumers no longer have to notify the Attorney General in pursuing the right of a private action. probably the single biggest impact of this law, and why we think that this is going to be much different than other laws out there, is that there is a right of a private action. We know, as a matter of fact, that a number of class action litigators are looking to build class actions against organizations, and unlike GDPR, which is mainly implemented by in-country privacy regulators, this is one where you're going to see the litigators going after too, and that's why we think this one is different. Likewise, that there are some exemptions out there, GLBA, HIPAA, and other exemptions out there. It's still, there's still some uncertainty in GLBA. Pursuant to GLBA, the way that these exemptions are worded, it's not a clear-cut case whether Graham-Leach-Bliley Act data, to what extent it's exempt, and what needs to be complied with that. And matter of fact, we're dealing with a number of financial services firms on this. Half of our clients are taking a conservative approach, saying we're not going to depend on the fact that GLBA, for example, data is going to be exempted from that. The other half are saying, well, we think we're covered. We think we're okay. We think that we're exempted from this. There are some other implications on this coming up in other states coming up, but there are some exemptions out there. The hard part about this law, and this is, by the way, one thing that we expect the Attorney General, this has been a big focus of discussion in the public hearings this last month on this law, is what is considered personal information. Today, the Act is very, very broad in its definition. It's basically is inferences drawn. If you have some data that can somehow be inferred to connect to a resident or an individual, that is their considered privacy information. Well, that's a pretty big area. I mean, it's not only the typical stuff we think of privacy, which would be name, address, phone numbers. It could be IP addresses, geolocation data. I mean, it's a fairly wide breadth, and we're hoping that this definition will be narrowed a little bit, because it's actually very easy to infer something about an individual with just a little bit of metadata associated with that. So this is an area that we're watching very, very carefully. Again, a lot of the companies that we're working with, we are watching it and taking a conservative approach, saying, hey, we're going to have to at least have a strategy in place right now that it's going to be the wider implementation, the wider description of personal information. All right, who is impacted by CCPA? Well, it's a business, so if you're state and local, you're exempt. That you collect or sells personal information from or about California consumers. And so, as we alluded to earlier, this is about California consumers. It does not have any location requirement of having the entity being located in California. There are some restrictions in terms of the size, revenues in excess of 25 million, and also if you're a data processor. But basically, unless you're a small organization, or you're a nonprofit, or you are a state and local or some other type of public sector organization, chances are pretty good that if you have any California customers, or if you have any California employees, that some aspect of this law will actually impact you. And we're based in California here at Contoro. We talk from time to time to our legislator, assemblymen, as well as others out there. And just the view from the California trenches is we don't think this is going away. I think there is a lot of frustration, quite frankly, on both sides of the aisle in terms of how privacy information is being managed. Some of the more liberal are very concerned that privacy information was used by Facebook to sway the last election. We can debate whether that's true or not, but there's a perception out there. There's also a real fear among some of the conservatives that we talk to that, what are they doing with our data and how are they using it? And there's not necessarily a friend. One of the big concerns we hear from some organizations, and this is legitimate, is really this law we hear should be aimed at the Facebooks or the Googles or the LinkedIn, the real data processors out there. Unfortunately, what's happening is all businesses are being swept up on this. And nor have I've heard the sentiment by some saying is that, well, no, they're gonna reduce the scope of this, so it only really is at those large data processors, the Googles and the Facebooks of the world. We don't really see that happening. And so just the mood we're seeing here in this state is that this thing is going forward. Now, again, as I said, a lot of implementation details we have to watch out for, and we still could see some changes. We might see CCPA change before implementation with either consumer rights or the compliance requirements, or maybe some exemptions or not. We're obviously going to get some further guidance. We talked about that. We talked about the definition of personal information. And the other question is, what's the effect of existing California privacy laws out there? How is this legislation going to impact that? So I also want to make one other comment that we think is very important. For those of you that have been through other privacy legislation, specifically the European General Data Protection Regulations, the GDPR, there was a significant amount of effort in GDPR trying to interpret what the rule would mean, in part because European legislation tends to be more principle versus rule-based. And I mean, it was a whole art to deciphering GDPR from a policy perspective. And you see a lot of organizations that put a lot of effort in terms of creating privacy policies around GDPR. And one of the arguments is that some of these policies were created sometimes at the expense of execution. And we're hearing, at least in the world of GDPR, that, well, execution's out there, and you see it wasn't that bad. Now, we actually think that there's going to be a one-year moratorium, and come this spring, we're going to see significant more enforcement of GDPR. But the point we're trying to make here is that be careful with CCPA. This is a little bit different. We actually think that CCPA, as it begins to evolve from a policy perspective, will be much easier to understand. We think that the bulk of the work on CCPA, the vast bulk of the work, will be on the execution of it. We also think that organizations that wait for certainty or prescription or clarity, either from the Attorney General or other sources, on what parts of this law is going to mean, are going to be in trouble, because there's a lot of work to be done, and we don't know everything about the law today, but we have a pretty good idea, and we can do a lot of work today. We think the risk is that if companies wait and see, it's going to be too late and the deadlines are going to come up. And not only will, as I alluded to, do you have the risk of inviting regulatory scrutiny? We think that the right of a private action, the fact that class action litigators are going to go after this for those companies that are unprepared, is really a significant risk. And so, again, we're working with a lot of companies, some in California, some outside California, and we're seeing a lot of organizations take this seriously now, in part because there's not really a lot of time to be able to manage this. So very, very important. Now, does this impact just California? No, actually, we believe that this law is going to be a template for many other state laws or potentially other federal privacy legislation. And we saw this before. Just going back a little bit of history, some of the original breach notifications started out in California. Matter of fact, the original breach notification law in the United States was an incident caused by a breach of a state of California employee database. And what happened in 2002 and 2003, all the way up and through the last decade, is state after state began adopting similar type of breach notification legislation today, that virtually all states have breach notification laws out there. But this is something that sort of started out west and moved east and a little north and south to Alaska and Hawaii, but moved. And we believe that the same thing, and we're beginning to see some emerging legislation, and we're following different states coming out there. Right now, we're sort of the rumor mill about what states are going to have what, but we think that this spring we're going to see other states that are going to be following suit. And eventually, we're going to see other states, many other states that we believe that will adopt similar legislation. This is very important because for those organizations that are just trying to look at the strictest components of California CCPA, California Consumer Privacy Act, the risk is that Other states may have slightly varying legislation or may not have the same exemptions or may have slightly different implementation guidelines. And so the best practice for organizations is going to be to have a general privacy, agility, and capability, not based on any single state. And so again, the message here is, if other states adopt it, think about a wider privacy strategy, a smarter strategy. We'll talk about this during this whole webinar series on how you approach it and what you need to do. But this is not just about California. I know some are hoping to say, hey, we're just going to wait until it's all done and then it'll just be California. And unfortunately, it's going to be much wider than that, we think. And by the way, we're speculating as much as anybody else whether there will be federal privacy legislation. There's already been discussions in the Senate over the last 2 or 3 months over that. We think that the hurdles are bigger for federal privacy legislation for the simple fact that there may be an effort to synchronize any new federal privacy legislation with existing privacy laws such as HIPAA or other requirements on that, and that could be more effort. I think you could argue it would be helpful if there were a single federal privacy legislation that superseded all of the California and potentially other states' laws out there. But we think that this is very important. So how is this different than GDPR? We do believe there are a lot of similarities between this privacy legislation and GDPR. But there are some differences. You know, the scope is a little bit different. The personal information different. Security is a little bit different. The disclosure is a little bit different. And then there's, things such as data protection impact assessments and breach notification, data protection office that don't apply to this. At its fundamental level, I think it's probably more similar than not. Organizations that have done GDPR work can clearly leverage a lot of the work they've done on GDPR, but it's not a copy and paste of GDPR to comply with CCPA. There are some new requirements and some new rules that organizations need to do. So again, what we're seeing organizations do is go out and leverage that to the extent that you need to have that out there, but don't be limited in that. So one of the things that we recommend starting is developing a maturity and roadmap, defining maturity and developing a roadmap. Complying with this law requires a lot of different capabilities, and it's going to be different for organizations. If you're an organization that has a lot of privacy information, that's fairly dispersed, a lot of systems, it will be a lot more effort. If you have limited privacy information, it's going to be simpler for you. And likewise, there's an argument to be made on here. What we're going to call reasonable good faith efforts to be able to comply with the law? Any type of information governance, you can't be perfect. So knowing we're not going to be perfect, what's an acceptable level for our organization to balance the risk and the cost associated with this that will provide defensibility, but still will be something doable. And so we're seeing a lot of organizations start out this process by defining the maturity where they are today and where they need to be, and then having a roadmap to address all the pieces. And the reason a lot of organizations pick a roadmap because there's a lot of different components to this that organizations want to put together, and how do you balance who does what, and likewise what's going to be involved and what are the resources, and are we going to be done in time? So don't get too caught up on the roadmap, but like any endeavor, the more that you can figure out where you're going, sometimes spending a little bit of time up front doing the roadmap process can actually save a lot of time on the back end because it will allow you to focus on the right things and be more efficient. So by the way, we get this question sometimes, and we're going to be using this model throughout much of this 9-webinar series where we're going to go through the different components of the roadmap. We're talking a little about the size assessment and roadmap. We're going to be talking a lot more detail about the personal data inventory. We're going to be delving into more of these different components of it. But basically, we think that the way to execute this law and not get stuck is to assess where you're at, put in some of the foundational components, look at implementation, go to the execution, and then likewise at the bottom you can see we have the organizational component of it broken into these steps. And so We've road tested this approach a number of different times. We believe that this is the most efficient, effective, and least likely way to get stuck in terms of taking an overall roadmap approach. So starting out, one thing we alluded to was what's involved in a roadmap. What are some of the pieces on there? Here's what we think are some of the key questions organizations should ask themselves is, what personal data do you have in Collect Store? Where is it located? How do you classify the personal data? And by the way, at the assessment phase, we're not necessarily saying you have to do a complete personal information inventory, but at least have a scope of where it is and how much is out there. What are your current privacy policies? How do you manage it? And then likewise, if you're being asked to, how much effort is it to protect this and to be able to report on this? How much effort is going to be able to do this? Do you want to focus on structured data to begin with? Do you want to focus on unstructured data, such as files? Do you want to look at semi-structured data, such as email? All those are in play. How much is paper out there? How much can you leverage existing processes? These are all key questions that we think that are fairly important to ask early in the process. So, as promised, we're trying to make this a fairly short and concise webinar, and so I'm going to be taking some questions. We've got a few questions here. I'll be able to answer that, but I wanted to make sure that we can get done with this part within the 30 minutes. Briefly about Contoro, we're the largest provider of information governance and privacy consulting services. We work with more than 30% of the Fortune 500. We don't sell any products. We believe we're doing more California Consumer Privacy Act projects than almost anybody out there right now, as well as a variety of other information governance projects. So we have those available. We do offer an on-site seminar. We're doing some of these. A very good way to get everybody together in an organization. If you're in the privacy or legal or IT group, and then you say, hey, I really want to involve other stakeholders, explain to them this is what this is about. We do offer this on-site seminar. It's not a sales pitch for Contoro, but it really talks about what are organizations doing and how are they approaching it. Some of the content will be very similar to what we're doing in this 9-part seminar series, but obviously a little bit more concise because we hope to fit it in 2 hours or less. And likewise, we can tailor it to what we're seeing in your industry. We've worked with enough companies. And likewise, at Contoro, we offer a variety of California Consumer Privacy Act, as well as GDPR and other types of information governance consulting services. We do assessments and roadmaps and organizational development, lots of inventorying, policies and procedures, all the way through security controls and data placement strategies, remediation. A lot of work helping organizations be able to do that. And then again, as background, both for this, in these webinars, we do tend to gloss over some of the details. And so we have some white papers. Email us at info@contoro.com. We've got a couple white papers. We also have a lot of other content happy to share with you, not only CCPA, but ancillary topics such as records management, defensible disposition. We're doing a lot on production processes out there, helping organizations. So again, we know we're going a little quick on this. We know that we're glossing through this a lot of it when we keep 30 minutes, but email us for those white papers at info@contoro.com. Happy to walk that through with you. And then likewise, we're going to talk about our next one saying, okay, how do you actually plan a state law privacy project? And again, we're sort of assuming in this that it's going to be soon more than just California. That's where we're calling it a state privacy law project, what's involved, and then we're going to go all the way through. If you miss any one of these webinars, recordings will be available. And so happy to make that available. And with that, we are just at the bottom of the half hour. And so have some questions here. Want to be able to present that. What is the greatest risk to a company who does not sell direct to consumers but collects personal information from individuals? Well, you don't have to sell. The fact, if you have personal information from individuals, obviously the risk is if you have some sort of breach or you're not compliant with it, the fines could be fairly heavy based on how much information is out there. And as I said, it can be $750 or damages, the greater of those, and that could quickly get very, very expensive. We actually, and I'm going to make this comment too. Some people are saying, hey, boy, Facebook and Google, to pick on them, they're the ones really at the biggest risk with this project, with this initiative. And I'm actually going to make the argument, no, they've got entire teams of people and they've been anticipating this. I actually think it's the next level down or the level beyond that. It's those that are not prepared. And it may not come from a regulator or an attorney general. Maybe it's going to come from a class action litigator going against you. So again, just because, so the risk is you could be sued and you could face significant penalties based on how many California consumer information that you're not complying with or did not manage securely or had breached. And so, and those numbers get very, very big very, very quickly. So a lot of organizations are at risk. And we've got one last question out here, which is who typically runs these projects? Typical question. We're finding a steering committee. It's, privacy and legal and compliance and IT and the business units. No single group we're seeing owns all of this. We're seeing a variety of them. All right. With that, we are out of time. I know a bit rushed. Thank you for joining us today. Join our next webinar session on this topic, and we wish you success as you move forward and comply with the California Consumer Privacy Act. Thank you very much.